Stop scrolling right now. If you or anyone in your family has a pending green card application, an immigrant visa petition, or you are from one of the 75 countries hit by the new federal immigrant visa pause, this next 60 seconds could decide whether you stay in America or get sent back. I am immigration attorney Sue Clarke with the Sue Clarke Law Group, and in the next few minutes I'm going to break down the 3 biggest immigration bombshells that dropped in late January 2026. What they really mean for you, why thousands of families who did everything right are now panicking, and exactly what you must do today to protect your future before it's too late. Don't skip this. Stay with me till the end, because the rules have changed overnight, and most people still don't know how exposed they really are right now in March 2026. Let's begin with the first and broadest change. On January 21st, 2026, a federal immigrant visa pause went into effect for nationals of 75 countries worldwide. This is not a travel ban or tourist visa suspension. AITI is a targeted pause, limited strictly to individuals seeking permanent residency through consular processing outside the United States. An immigrant visa is the document issued to someone who plans to live permanently in America. Common pathways include family-based immigration, such as a U.S. citizen filing for their spouse or unmarried child who is still living abroad, or a green card holder petitioning for their son or daughter overseas. AITI also includes employment-based cases. If you are currently sitting at a U.S. consulate waiting for your immigrant visa interview so you can enter the country and receive your green card upon arrival, this pause directly applies to you. The pause also hits high-skill employment categories hard. If you are applying under the EB-1 Extraordinary Ability route as an athlete, scientist, researcher, or world-class entertainer, or if you are an EB-5 investor who has already put in the required $1 million investment into a U.S. business and are now finishing the consular process from abroad in one of the 75 affected countries, this freeze affects you too. Even after investing a full $1 million into the American economy, you are not exempt if your final step is happening through a consulate outside the United States. The government's official reason is the public charge doctrine. Federal officials say they need extra time to thoroughly evaluate whether applicants from these 75 nations might become dependent on public benefits once they arrive. This is the long-standing legal test that looks at whether an immigrant is likely to need federal assistance programs, such as Section 8 housing subsidies, SNAP food stamps, Medicaid, or other government-funded support. The administration is applying this rule more broadly than in previous years. Here is the crucial clarification that is still causing massive confusion among applicants. Tourist visas, B1, B2, student visas, F1, J1 exchange visitor visas, O1 non-immigrant extraordinary ability visas, all H-category temporary work visas, and business visitor visas remain completely unaffected and are being processed normally. This pause is only for permanent immigrant visas handled through consular processing abroad. Importantly, if you are already physically inside the United States and have filed Form I-485 for adjustment of status, for example, you entered on a valid temporary visa, married a U.S. citizen, and submitted your entire green card application from within the country, this pause does not touch your case at all. Your application continues to move forward under the normal jurisdiction of U.S. Citizenship and Immigration Services, USCIS, inside America. The Department of State has publicly stated that consulates are still accepting new filings, scheduling interviews, and completing administrative processing. However, the final and most important step, the actual issuance of the immigrant visa stamp in your passport that allows you to enter the United States and immediately receive your green card, is currently suspended until further notice. Now let's move to the second major development that has shocked the immigrant community. Immigration and Customs Enforcement, ICE, has officially confirmed through both internal guidance and on-the-record public statements that AITI is now actively detaining individuals who have pending adjustment of status applications before USCIS, even when those individuals possess valid, unexpired government-issued employment authorization documents, EAD work permits. This marks a dramatic departure from decades of established practice. For many years, the simple fact that you had a pending green card application with USCIS was understood to offer a layer of protection while your case was under review. The assumption was that if you entered legally, filed correctly, passed biometrics, received your work permit, started paying taxes, and were waiting patiently for a decision, ICE would generally leave you alone during that waiting period. That unwritten protection has now been removed. ICE leadership has made AIT clear that their priority is to accelerate removals and move cases through immigration court at an unprecedented speed. As a result, the existence of a pending petition no longer acts as a shield against detention. In practical terms, this means a foreign national who entered the United States legally on a valid visa, married a U.S. citizen, filed for adjustment of status, attended their biometric appointment, received an EAD, is legally working, paying taxes, and raising a family, can still be detained by ICE officers at any time. Thousands of honest, law-abiding families who followed every single rule are now living with this new daily fear. The third development has caused the most emotional distress among parents and families. Multiple documented incidents, including several handled directly by our law firm, show that ICE officers are now deliberately conducting enforcement operations at school pickup lines, school parking lots, and other locations where parents are predictably present because they are picking up or dropping off their children. One of the most widely reported and heartbreaking cases involves 5-year-old Liam Conejo Ramos. His father, a lawful permanent resident who had a pending immigration matter, was taken into custody in a school-adjacent enforcement action. The incident quickly went viral and sparked nationwide outrage from child welfare advocates, legal scholars, educators, and families on all sides of the political spectrum. The criticism centers on the fact that immigration enforcement is now reaching into spaces that were long considered off-limits, the daily moments of family life at school. Many of the parents being targeted actually entered the United States through legal ports of entry. They hold pending adjustment applications. Their spouses are U.S. citizens or green card holders. They have jobs, pay taxes, and have never had any criminal issues. Yet they are being swept up in the current aggressive enforcement priorities that no longer distinguish clearly between those who entered without inspection and those who are simply waiting for their legal green card approval. So what should you do right now if any of these three changes affect you or your loved ones? If you are a national of one of the 75 countries and you have a pending consular immigrant visa case, do not give up or abandon your application. Keep filing every required document exactly on time. Maintain meticulous records of every submission, every receipt number, every email, and every scheduling confirmation. Attend every interview you are given. Do everything possible to maintain your admissibility. Avoid any new criminal issues, traffic violations, or anything that could create a ground of inadmissibility. Stay in daily contact with your immigration attorney so you can respond immediately the moment the pause is lifted. If you are inside the United States with a pending adjustment of status application, preparation is now your strongest protection. Always carry your employment authorization document and a printed copy of your pending petition receipt and approval notices. Save your attorney's direct phone number in your phone and write AITI on paper in your wallet. If ICE ever approaches you, remain calm, politely identify yourself, and immediately present your documents showing the pending case. If you are detained despite your pending application, remember that having a strong pending petition plus deep community ties, employment, and family in the United States greatly increases your chances of being released on bond. Never resist, never run, and contact legal counsel within the first hours. Every family must create a detailed emergency plan today, before anything happens. Make sure your spouse, children, and close relatives all have digital and physical copies of your passport, visa, I-485 receipt, EAD card, and attorney contact information. Decide in advance who will take care of the children, who will call the lawyer, and who will notify your employer. Run through the plan together so no precious time is lost if an arrest occurs. If you are a parent worried about school-related enforcement, immediately arrange for a trusted U.S. citizen family member, neighbor, or close friend to handle school pickup and drop-off. Update the school's official emergency contact list this week. Teach your child the exact name and phone number of the backup person. In the event of any detention, immediately give ICE the name and contact details of the designated caregiver so your child is never left waiting alone or taken into any facility. The immigration enforcement landscape in 2026 has changed in ways that no one predicted even a year ago. The protections that generations of immigrants once counted on are no longer guaranteed. But solid knowledge, careful preparation, and immediate legal action are still extremely powerful tools that can make the difference between staying with your family and facing removal. I am immigration attorney Sue Clarke. Please share this briefing with every family you know who is navigating the U.S. immigration system right now. Subscribe to our channel and hit the notification bell so you never miss a critical update as these policies continue to evolve week by week. And if you need personalized legal guidance for your specific case, reach out to the Sue Clarke Law Group immediately. Simply comment "Help" below this video or call the number in the description. The best time to build your defense strategy is today, while doors that are still open can still be protected. Thank you for watching. Stay safe, stay informed, and we will continue to bring you clear, accurate, and actionable immigration updates every single week.